Thanks so much for joining us today and spending your coffee break with SB Sarah. My name is Adam Sands. I'm one of the communications officers here at SB Sarah. And we have the good fortune of being joined today by Barbara Hanna, our Senior Staff Counsel.
Good morning. Thank you for joining us.
And we're also joined today by Christine Coe. You won't hear her on the webinar, but you'll have an opportunity to chat with her. She is one of our retirement specialists, and we're glad that she's able to join us today. But in the bottom left-hand corner of your screen, you'll notice the chat box. Looks like now I'm able to highlight it. As we go through the presentation, feel free to type in your questions, submit your questions, and Christina would be happy to respond to those. Barbara can try to respond as well accordingly. And then in the bottom right-hand corner of your screen, just highlighted that folder icon. If you click that folder, you can download a number of different presentations and various documents. You can actually download today's coffee break presentation. So if you'd like these slides for future reference, you can download them there, as well as the rest of our coffee break presentations that we've conducted throughout 2017. So feel free to check out that folder icon and download anything that you see fit. So thank you again for joining us. Today we'll be talking about marriage and your retirement benefit. So we'll be talking about what options your spouse or domestic partner would have should you predecease them, and then what to do if there has been a divorce in the course of your SB Sarah membership. So first, just kind of a quick disclaimer that we always give. It's always important to know who your beneficiary is and to make sure that the individual or individuals listed on file accurately reflect your wishes. So the first question there asks, do you have a spouse, domestic partner, and is that person listed as your beneficiary? Now, Barbara, I understand that even if a member is married but doesn't have that spouse or domestic partner listed on file, that individual could still have rights that would supersede another named beneficiary.
Yes, you are
Is that
correct.
correct?
There are several provisions in the government code that would allow a spouse or domestic partner to receive a benefit despite the spouse or domestic partner not being designated. However, it is important to always have your beneficiary information up to date because there are benefits available that may only be payable to a beneficiary. So for example, our burial allowance upon the death of a retiree, that benefit is only paid to a designated beneficiary or an estate. So again, it's always important to keep your beneficiary information up to date.
Great, thank you. So should you pass away as an active member, a surviving eligible spouse or domestic partner would receive death benefits and may be eligible for additional benefits, survivor benefits, and as Barbara noted, that burial allowance. So the topic of death benefits for active members is somewhat in depth, so we won't spend time on that today. However, we do have a link there if you'd like to learn more about options for your beneficiaries should you pass away as an active member. You can go to that webpage and read more, and you can also download one of our Retirement 101s on the topic in that folder icon. But what we really want to focus on today would be options for your beneficiaries as it pertains to your retirement benefit. So should you predecease your spouse or domestic partner in retirement, and then again at the end we'll talk about what to do if a divorce has occurred during your SB Sarah membership. So I know there's a lot of information on this slide, there's a lot of content, so we'll leave this up here for a while and let it sink in. We'll kind of just talk over this for a bit. So what you have listed here on screen are retirement options. So part of the service retirement process, so when you go to retire, you'll select an option as to how you wish to collect your retirement benefit, and then how benefits would be distributed to your eligible spouse, registered domestic partner, or another named beneficiary upon your death. So for today's purposes, we'll assume, since the topic is marriage and your retirement benefit, we'll speak about options for a spouse or domestic partner more specifically. So the various benefit options are listed there on screen in the table. The most commonly selected option is the unmodified option. Now that provides 100% of the benefit for which you are eligible, so it's your maximum benefit in retirement. And then should you predecease a spouse or domestic partner, that person could receive a 60% 60% continuance of the amount that you are receiving for the rest of their life. Or they would have the option of alternatively selecting for a lump sum payout of any undistributed refundable contributions remaining in your account. Now, Barbara, with regards to that lifetime monthly continuance, we use the term eligible spouse or domestic partner. So it sounds like there may be some specific criteria around that. Could you speak to some of the requirements for that continuance?
The term eligible surviving spouse, under the unmodified option, in order to be deemed an eligible surviving spouse or domestic partner, the person must have been married at least 1 year prior to the date of retirement. Or in the event there is a post-retirement marriage, then an eligible surviving spouse must have been married to the member at least 2 years prior to the date of death, and the person has attained the age of 55 years on or prior to the date of death. So those are the two instances in which a person would be deemed an eligible surviving spouse.
Great, good to know. So again, that's 1 year prior to your effective retirement date. So if you've only been married, let's say 10 or 11 months, and you're getting ready to retire, you're signing that paperwork, technically you would not be able to select that person at that particular time.
Yes. So for purposes for retirement, and you can name that person at that time, it's just upon the death of the member, that person may not have been eligible to receive a benefit as a surviving spouse at the time of the member's death.
They would have to meet that other end of the criteria, 55 years of age at least at the time of death, and 2 years of marriage. Okay. Thanks for clarifying that. So again, that ends up being the most commonly selected option, though not necessarily the best option for you. Ultimately, that's a decision for you and your spouse or domestic partner to make together. But again, it can provide for that lifetime monthly continuance and perhaps give some additional flexibility for your loved one. As you can see on screen, options 1 through 3 provide a reduced lifetime monthly benefit for you based on your life expectancy. In option 1, sometimes this is selected when the member doesn't expect to live particularly long into retirement and determines that a greater amount could be left to the spouse domestic partner as a lump sum distribution. Options 2 and 3 provide a reduced lifetime benefit for you based on your age and the age of the beneficiary, so there's a bit of a actuarial calculation there. Option 2 providing your spouse or domestic partner with 100% lifetime continuance of that reduced amount that you are receiving. Option 3 provides a 50% continuance of that reduced amount you were receiving, although the reduction to you, the member, is less than that of option 2. And then option 4 is kind of the designer option, if you will. It provides custom continuances to one or more beneficiaries. And Barbara, I understand that this option ends up often taking place in situations of divorce, whether court-ordered
so often when there is a division of retirement as part of a divorce, option 4 may be the option that the parties often agree on, because it provides the ex-spouse a benefit for his or her lifetime after the death of the member, and also at the same time the member can also name his or her current spouse or domestic partner as a beneficiary as well to receive a continuance of the member's retirement. So this is why it's called a custom option, because you can name multiple beneficiaries to receive a benefit, especially in a divorce, so that you can name your ex-spouse as well as name a current spouse. So that's why this option 4 is usually agreed upon by the parties.
Now, Barbara, I understand that with options 1 through 3, the individual who is designated as the beneficiary, once you've made that selection, you're not able to change that in retirement. So, if, for instance, you're unmarried at the time of retirement and you do get married post-retirement, would anything be available in a service retirement for
That's actually a great
spouse,
question.
domestic partner?
The government code indicates that once you receive your first payment, under whatever option that you may receive, you are unable to change your options, meaning that you're also unable to change your beneficiary to whom that benefit would be payable to. So that's where the difficulty lies, is that once you select an option and designate a beneficiary for that option, you are locked into that selection at that point with those particular options.
With those particular options, yeah.
You're welcome.
Yeah, thanks for clarifying that. So the last slide, we noted option 4, which is often involved in situations of divorce. So with that, I'm not an attorney, but thankfully Barbara is, so she can talk about what happens if a divorce occurs during your SB Sarah membership. So California is a community property state. As such, retirement plan benefits earned during your marriage may be considered community property and subject to division upon dissolution of that marriage. So, Barbara, what should a member do if they've gone through a divorce, and maybe it's something that's recent, or maybe it happened 10, 15 years ago as an SB Sarah member, they never turned in their paperwork?
Well, if I could just
what should be their
first
first step?
Indicating that this is not intended as legal advice, I can kind of walk you through what SB Sarah requires of our members when notifying us of a pending dissolution. So it's important that when a judgment is entered in your dissolution proceeding, that you provide SB Sarah with a copy of your judgment. The judgment will be reviewed by legal services. We have in-house attorneys here. I'm one of two. And SB Sarah will then send you a letter informing you if there are any further actions required, such as the filing of a joinder and a DRO, if there is a division of retirement. And I know we have DRO, domestic relations orders, frequently asked questions available on our website as well. So take a look at those if you have any further questions. And then also, in the event if there is not a division, we will still send a letter to you informing you that we have reviewed the judgment and that there's no further actions required. So just going into a little bit of what I know I threw out some terms earlier, what's a joinder and what's a DRO. A joinder is essentially a court document that joins SB Sarah as a third-party claimant to your dissolution proceeding. Once that happens, the court now states or indicates that they now have jurisdiction over the retirement property, the retirement funds here. And at that point, SB Sarah is unable to pay out any benefits until it's resolved, whether it's by a domestic relations order or by some other court order. Now, what a domestic relations order is, it's a court order that provides instructions to the retirement system of how to divide the benefit. So those are some of the documents that we require in order for this to be resolved. And that's only in the case that there is a division of the retirement. And we would only know that if we actually review your judgment indicating that there is a division that the court made as part of your dissolution. But in the event that there is not a division of retirement, you may not be required to actually provide those subsequent documents to us, a joinder or a DRO. So again, let's just go back to the beginning. It's important for you to provide us with your judgment so that we can kind of inform you of what's required next of you.
Now, do you ever see judgments where maybe it doesn't really speak to SB Sarah benefits, or perhaps the language is somewhat vague and unclear? And if so, what typically happens in those situations?
There's several things that could happen depending on the ambiguous nature of the language in the judgment. So clarity is always important. So whether you or your attorney are drafting the letter or the judgment, it's important to have clarity as to regards to your SB Sarah benefits. So sometimes when we don't have a clear indication of a division, or it's just unclear that it's even referring to SB Sarah, we may require the member to sign a form which is known as a liability release. Or in some instances, we have required the member to go back to court to obtain further clarification from the court as to their SB Sarah retirement property. So those are the instances in which clarity can help. And if it's not there, we do try to assist the member in kind of telling them what is required to get this resolved.
So again, if you'd like to contact us for more information, here's our information up on the screen. We are happy to answer any questions you have with regards to those retirement options that we talked about and what would be available to your spouse or domestic partner. And as Christine and Barbara noted during the webinar, very important to provide a judgment if there has been a divorce in the course of your membership. Provide that judgment to us if you haven't done so already. So with that, thanks so much for joining us on this coffee break. We appreciate you hanging out with us this morning. And I know that some of you probably have to get back to work, so we want to be respectful of your break time.